This is the August 9th, 2019 regular meeting of the Rehoboth Beach Planning Commission. And call to order. Let's have a roll call, please.
Okay. Mr. Trunzo?
Here.
Let's see, Mr. Perry?
Here.
Ms. Lucier?
Here.
Ms. Gay?
Here.
Chair Mellon?
I'm here.
Myself, and joining us is Glenn Mandelis.
We know Paul Hubbard was not going to be here, and I don't know about Mike if he's still recovering.
Or Lee.
Or Lee.
Or Lee. Yeah. Okay, is what it is. I've been told by Ann. Ann had her eye surgery yesterday and is apparently doing well, recovering, but we do not have any minutes to approve. So let's go on from there. We do have a number of correspondence, but they deal with one of the issues that we're going to be talking about. So we'll hold off on reading those in until we open that up. Let me just make a statement. I don't know if there's anyone in the audience that has appeared today because they thought they had been notified as a property owner near the Baltimore hotel that is being proposed, that there would be a hearing related to that. It was to have been on our agenda. Unfortunately, the city found out too late to notify, really to re-notify everyone, that there apparently was some form of error in the mailing lists that had been created. And so some people who should have been notified, who are within the 250 feet of the site, were not notified. And so ultimately we advised the solicitor, who in turn talked with the lawyer representing the Langford property, and it was agreed, I think concurred, that we would defer, although there was perhaps a low risk, but that we would defer any discussion on that matter until at least 1 month. The city is working on trying to find out, A, what the problem is, and B, correct the problem. It affects not only us, but it affects notifications for Board of Adjustment. So it's a very important thing. It's high on the importance list for the city, but I have not heard whether it's been resolved or not. So we felt that the best decision was to defer in case someone who fell within that 250 feet radius might have objected and did not hear. I apologize because there are some people that did get notified, and now they've complained because they didn't get re-notified that there wasn't a meeting. So, but with a list that we're not quite sure if it gets to the right people, it's sort of hard to do. It was noticed properly on the city board, and I believe that the papers were notified. Is that correct?
That's all correct. Yeah, part of the problem, I guess, is the city is transitioning right now, it has been for some time, from its Main Street system, which is the property management system, to the Munis system, which is another software platform. And it's those two systems and the way they talk to Sussex County about addressing something, there's a glitch there somewhere. It's predominantly, I think, in the condo units, they're only recognizing the overall property owner, not the individual units. So we're getting through it, and I'm sure it's going to get fixed. But for this one, given the size and magnitude of the project, we decided probably best to put it off until we're sure everybody's appropriately noticed.
So we apologize.
And is it likely to be on the September 13th agenda then?
I have not heard from Sharon. I mean, we hope that it will be,
Okay.
But I have not heard from Sharon whether the source of the problem has been identified and whether it's corrected yet.
Right. The other thing I can add is I've spoken with their attorney, and they are considering some of the things that Mike Strange said last time about the look and feel of the building and whether the balconies make sense or don't make sense. And they're considering potentially a Board of Adjustment application to ensure they can do some of the unique facade type things that they want to do, based partly on, at least according to them, based partly on Mike Strange's comments last time.
Didn't they already go to the Board of Adjustment?
It should be trip number 2. Yeah,
Okay.
right.
Okay, so well, apologize for that, and we'll get on with other business. Item A is to discuss possible zoning classification change for 330, 228 Rehoboth Avenue, State Road, parcel as requested by the Board of Commissioners and provide the Board of Commissioners with any recommendations. Before we get into that, I'd sort of ask Glenn to maybe give us a little update as how that got to us. And also, I guess I'll make a request for the Planning Commission. It did not come via a actual proposal by the Board of Commissioners. It was sort of word of mouth, I think.
Right, so,
And what I would request is, I think the proper way is in fact to make a proposal and to tell us what the bounds are.
right, so this came into the city from, the written correspondence that you have, I think you'll have the package from David Hutt at Morris James, who's sitting here. Typically what will happen, and historically, we do not get a whole lot of change in zone requests. There's been half a dozen over the past 6 to 8 years, if that many. Generally, what will happen is the correspondence will come in, it'll get forwarded to the Board of Commissioners. The Board of Commissioners will meet. They rarely have any substantive discussion over the application when it comes in. Typically, it's been routine in the past to forward the application for a change in zone to the Planning Commission. This one came in, and for one reason or another, administratively, it sat on the shelf and didn't get passed to the Board of Commissioners as quickly as it typically does. So at the last voting meeting, I believe, of the Board of Commissioners, I let them know that we had not gotten it in front of the Board of Commissioners as timely as we typically do, and if there were no objections, we were going to administratively refer it to the Planning Commission. So the Board of Commissioners never took a vote to refer it to you, but nobody objected to an administrative referral. It's not the typical process, and it's not the process that we intend to adopt going forward. So should another one come in, we would hope to timely get it in front of the Board of Commissioners. They would vote like they have in the past to refer it to the Planning Commission for a recommendation. So it has been administratively referred to you all. Your job is to review the application for the change in zone and consider whether you think it's consistent with our comprehensive development plan and other standards in the law for rezoning applications. And to the extent you think it is or is not, however you come out, you'll take a vote at some point on a recommendation to the Board of Commissioners. The Board of Commissioners then will take that recommendation into account and make a final determination as to whether this property should or should not be, whether the zoning should be changed. I know you're all aware that there's, because this property's been before you previously on a potential site plan review. I think you saw it on the concept review initially. As you know, there's some litigation that's pending over the lease agreement for the current tenant, and there's at least one attorney here who's on the plaintiff's side who's interested in what all is going to occur today. The only comment I'll make is that litigation should not impact your thoughts on whether a change in zone for this location makes sense or not. There may be reasons that I ask the Board of Commissioners to delay making a decision or to go ahead and make a decision at some point, but at this stage, my view is that there's litigation pending. Your role as a Board of Planning Commissioners is to simply apply the standards that have been set out in the law and set out in our comprehensive development plan and make a recommendation purely on whether it makes sense or does not make sense to change the zoning of this property.
A slight minority opinion?
Sure.
Okay.
You're the chair. You can express any opinion you want.
Just, well, in looking, I actually looked through the city code to see how requests for zoning changes actually are initiated. And believe it or not, I can't find anything within the city code that really identifies how that process takes place. We know that the commissioners, as Glenn has said, are responsible for doing that, but it is not clear in the city code how that takes place. And there's probably logic to that, although I would think that anyone requesting a zoning change probably has to prove some degree of standing in making that request. So, I mean, and the reason I say that is I think of what happens in the county, and let's say the county has zoned a particular area because it wants the growth. Let's say they've zoned it such that it is residential and has a density of let's say 2 houses per acre or something like that. And all of a sudden, they come along and say, well, they could, on their own, say, gee, we really want the density higher because we want more people there. But the reality is that those kinds of requests usually start with an initial request by someone, a developer or someone who has an idea that he really wants to develop the land but needs a change. So I think the idea that we cannot, in fact, look at what the intended use is of the property is not exactly correct. I realize that you have to go forward sort of in a very general sense, but I think we have a right to understand what the potential use is, because we will be evaluating the impact of that property on the surrounding area and the rest of the city. So,
Well, I guess what I would offer on it is just to keep in mind that to the extent there's a change in zone on this property, anything in the commercial district that's permissible could eventually be put on that property. You can't be guaranteed that any particular application or any particular development proposal is going to eventually be put there. So maybe I could agree to some degree, to some extent, that it should inform your decision somewhat. But I also think that you should look at the whole entirety of the uses that could be applied to this property.
agreed. Okay. So, I guess, Mr. Hutt, you would like to tell us what you are trying to achieve?
Certainly.
And you would like to see one of these pictures, I think.
Certainly, if you can start with the survey, which is right, the boundary and topographic survey.
Let's go the other way. Try to get this bigger for you. No, wrong way. Let me bring up another one. Hang on for a second.
And the other option is to put it on the table, right? We can use the overhead.
How about that? Does that help you?
Yes, that's great.
Sorry about that.
Thank you.
Where there's a will, there's a way.
For the record, I think my name's already been discussed, but my name is David Hutt. I'm an attorney with the law firm of Morris James. This afternoon, I'm representing Limitless Development Construction Consulting 2 LLC, and I'm not going to keep saying that. I'm just going to call it Limitless from here on forward for brevity of reference. With me this afternoon is a principal of Limitless, which is Don Lockwood. And as it was introduced by the chairman and the discussion undertaken, today's meeting does relate back to a June 6th letter application that was filed for a change of zone at the property known as 330 Rehoboth Avenue. The opening comments of the commission, as well as their solicitor, were interesting to me because I experienced some of those same things and had some initial comments along those same lines. But at the outset, I would note that in looking through the Rehoboth Code, I also did not find a defined process for a change of zone application. I think I spoke with several people at the city, including Mr. Mandelis, about that process, which, again, the end result of that discussion was the June 6th letter, which brings us here this afternoon. The other two items that I wanted to sort of address at the outset were things that are not technically part of this application tonight. And frankly, Mr. Mandalis covered both of them for me, so I'm going to shorten up my comments on that. But first, as the commission knows and was discussed a moment ago, you've seen a concept plan for a potential hotel at the site. But that is not what is being reviewed this afternoon, is that hotel. In fact, I didn't bring any renderings or plans for a hotel with me. Certainly, that is one potential use that's listed in the category of permitted uses for the commercial zoning classification. But the direction, albeit an administrative direction at this point from the Board of Commissioners, is for a recommendation as to whether or not it's appropriate for the entire property there to have one zoning classification. As you know, it presently is split zoned with 2 zoning classifications. And so the question is whether or not it's appropriate for it to have one, and the request is for one commercial zoning designation for that. As was also discussed, you'll likely remember from January, any redevelopment of this site, whether it was a hotel, whether it was something else, would run headlong into this issue if they decided to move forward with a redevelopment of the property. The second issue is the landlord-tenant dispute between the tenant, which is the 99-year tenant, which is my client, Limitless, and the owner of the property, which is J.J. Stein, Roman numeral 3, Inc., which is the owner and landlord of the property. I do not represent Limitless in the litigation that's pending in court. There's another attorney and law firm that represent Limitless in that action. I believe we will probably hear from the attorney or attorneys for the landlord owner at a future time here in a few minutes. But to me, the good news this afternoon is that, as Mr. Mandalis indicated, the Planning Commission does not have to weigh in or wade into that litigation. I have not waded into that litigation. That litigation is pending in the Superior Court. It is scheduled for trial, as I understand it, in 2020. The only 2 comments that I have about the lawsuit at this time are that the emails, and I saw that they were listed on the agenda as a hyperlink to the packet of materials, the emails from the plaintiff with the property owner's attorney, while they state that there is an objection to any application filed by Mr. Lockwood, there's no land use concepts or thoughts that are in those emails, and perhaps we'll hear them this afternoon. But at this point, it appears that the objection is, and probably understandably since the parties are in litigation, but the objection is it's an application filed by Mr. Lockwood, the tenant, the defendant, and we object to that. But of course, this commission is asked to make a land use decision as to whether or not it's appropriate for that property to have one commercial zoning designation. The second thing I would say is that email came as a bit of a surprise to Limitless, simply for the fact that having the potential to have one zoning classification, one commercial zoning classification for this property, is beneficial to the property in general, regardless of whether Mr. Lockwood is the tenant and his company, regardless if there's a subsequent tenant, or regardless of whether or not the property at some point in time is back in the hands of the property owner, J.J. Stein 3, Inc. And so it was a little surprising that if somebody else is going to go to the effort and expense of trying to make the property one zoning classification, that there would be an objection, as, again, this relates back to this concept, but any redevelopment or revitalization of that property is going to run into this issue of the split zoning of the property. Having said that, I do want to focus this afternoon on, rather than on those 2 things, I want to focus this afternoon on the property and the substance of the application. As was indicated, the application is to change the zoning classification for part of the property. Part of the property is already zoned C1. There's a portion of the property that is zoned R1, and the request that's before the Board of Commissioners, and for which your recommendation is going to be forthcoming, is whether or not it's appropriate for the entirety of the property to have a C1 zoning classification. I'm sure everyone here is familiar with the location of the property and what its uses have been over the years. Presently, it is used by Limitless for office space, but there is probably no doubt and no argument in this room that Historically, it is much better known as the location of the Seahorse Restaurant. Most people who I hear around town still refer to it as the location of the Seahorse Restaurant, as that was the landmark restaurant as people entered Rehoboth Avenue, or the Avenue, for probably more than 30 years. In doing some further historical research on the property was, prior to being the location of the Seahorse Restaurant, was the Horse and Buggy Restaurant. And the Seahorse closed up around 2000, and after the Seahorse closed its doors, there was two restaurants that came in briefly. DiNardo's was there briefly, I believe, and then Chili Billy's came after DiNardo's. After that, the location was then used as offices, real estate offices for Ocean Atlantic Sotheby's, and has since been used by Limitless and some others for office space. Due to the age and condition of the building, a redevelopment of that property requires that the existing structures be demolished and construction of new improvements. And for all the reasons that have been mentioned previously, I'm certain that the filing of this application didn't come as much as a surprise to any of the commission members here, given that there was a discussion on January 11th about a potential redevelopment of this site, the concept plan that we discussed at that time. As you'll recall, that one of the goals of Limitless at the January 11th meeting was to flesh out the two possibilities, given the unique nature of this property and the two paths that it could probably go on. One path being seeking to change the zone so that the property had one single zoning classification, and the other path being, of course, that there would be a series of Board of Adjustment applications or one Board of Adjustment application with multiple parts to it to try to bring the property as much into conformity with the code, but then seek variances for those issues that arise due to the split zoning of the property. Obviously, since we're here this afternoon, the path that was chosen at this point was to file the change of zone application, and some of the choice in doing this was based upon the discussion that we had on January 11th. The two attachments to the change of zone letter application, I know there's no form as we mentioned, but the two attachments to that are the boundary survey prepared by Foresight Services that is presently on the screens around the room, and the other attachment is an aerial image that we'll look at in a few minutes, or a few seconds maybe. You can see on this boundary survey, and the boundary survey actually includes not only 330 Rehoboth Avenue, but also 328, and this application does not involve 328. That is under separate ownership and not part of this application. So the application is only 330 Rehoboth Avenue. As you can see on the survey, you probably can't see it from where you're sitting, but the total area of the site is 42,494 square feet, or just a little bit, about 1,000 square feet shy of an acre. If we can have the other image, Mr. Mellon.
And would you just clarify for us, that 42,000 square feet goes up to the last item on the left? Is that correct?
42,000 square feet ends right there, so it's everything from there.
Okay, so it does not include the I guess that's 328, is that?
Correct, this is 328.
Okay. Okay. So you would like to see the next picture?
Yes,
That one?
yes. This is an aerial image with the zoning map for this area of the City of Rehoboth Beach, an overlay as prepared by Scaled Engineering. And what this shows is the zoning line which runs through the property. You can see the zoning line, of course, at that portion of the property. And of the 42,494 square feet, the portion that is immediately adjacent to Rehoboth Avenue, or 23,067 square feet, is the commercially zoned C1 portion. The portion along State Road consists of 19,425 feet, and that is zoned R1. As you can see on the aerial image underneath the coloring for the zoning, and as I'm sure everyone's familiar, The structures are located on the Rehoboth Avenue side of the property and can take up much of the Rehoboth Avenue side of the property. And the parking for this building is located on the State Road side of the property, as well as the entrance comes in through the commercial section, but then you park in the R1 section for whatever the use has been. And in doing the historical research, the images that we have seen and the individuals that I have talked to who have more life experience in Rehoboth Beach than I do have indicated that what you see on the screen with the building on Rehoboth Avenue and the parking lot on State Road has been the configuration of the property throughout the entire history of the property that they are aware of. I think there was a Planning Commission member who commented that he had a 47-year history, and that was his recollection as well as to in the January 11th meeting. And the significance of that is that this means that this nonconformity has existed through the horse and buggy, through the Seahorse Restaurant, and all the other uses where you have a commercial building using residentially zoned property for its parking. And I'm sure that if somebody were to bring in an application along those lines right now, Mr. Molina would quickly have an issue with that because you can't use of course, a residential property for commercial purposes, which is what has been occurring for probably better than 60 years on this property. My guess as to the likelihood of why that has existed in this condition for that time is simply that the building and the parking lot have stayed the same, other than perhaps changing the name of the restaurant or something like that. But the difference now is that due to the age and condition of the building, if the site is going to be redeveloped, this issue, of course, raises its head because an application that's filed now will, of course, have to deal with the issue of the split zoning of the property, which hasn't had to have been dealt with in the past. As you likely recall, even from the conceptual review of one potential use of the site, much of Mr. Molina's review for that concept and many of the comments that we reviewed on January 11th related to having to negotiate the commercial portion of the property as opposed to the residential portion of the property and how those things interrelate with each other. Two of the things that were highlighted, and it's been said before I stood up and then after I've stood up as well, I have said it, but two of the things that I think are known about and are facts here that can't be controverted are any redevelopment of the property will occur, will raise these issues and have to be dealt with, and that there are essentially two paths to deal with those issues. One is the path that we're presently on through the June 6th application, which is a change of zone, and the other would be the multitude of variances to be requested through the Board of Adjustment process. In the past, I know at the January 11th meeting, Mr. Mandela spoke a little bit about to the commissioners regarding split zone properties and how in general land use concepts that is disfavored. And for obvious reasons, if we're going to apply it specifically to this property and this site, we discussed many of those. Mr. Molina's report highlighted some of those. But the initial one, and probably the largest hurdle, is, of course, that those two zoning classifications have different uses, and parking for a commercial enterprise is not a permitted use in a residential zoning classification. Moving beyond that to what I'll call more the nuts and bolts of the problem, you have issues calculating here in Rehoboth Beach the floor area ratio. Those issues were highlighted in Mr. Molina's letter, and as you may recall, if the whole property was zoned commercial, even the hotel concept was close to the FAR calculation. If the property were to stay split zoned, variances would be needed. I think that'd be a difficult decision for a Board of Adjustment as to how to regulate FAR on a split zone property and apply those concepts. Similarly, of course, you have area coverage requirements, and those obviously differ between the zoning designations and zoning classifications. Maybe the most obvious in every jurisdiction, whether there's a floor area ratio or not, would be the height, bulk, and area requirements that obviously differ between a zoning classification, a commercial zoning classification, and a residential zoning classification. When you put all of those things together, we discussed them at some length in January, and at the conclusion of the January meeting, Mr. Mellon took a straw poll of the commissioners and to gain a sort of a sense of where the commissioners were, whether they thought it was more prudent to seek a multitude of variances for any redevelopment of the site, or to go through the change of zone process that we're here on today. And the consensus of the commissioners was that it was a better process to have the property properly zoned with one zoning classification, and this would resolve the existing non-conforming use, and of course, help that as the, in addition to dealing with those nonconformities, it would prevent new nonconformities from arising with a redevelopment that had variances and those sorts of things. One of the other things that several commissioners highlighted then was that, assuming that the property has one zoning classification, that they would hope that the city would anticipate and that the developer would anticipate that no variances would be necessary due to there being only one zoning classification on the site. And certainly, speaking on behalf of Limitless, that is something that they recognize, is that there shouldn't be the need for a variance, for a slew of variances for something if there is one zoning classification that applies to the entire 42,000 square foot part of the parcel. In looking at the comprehensive development plan for the City of Rehoboth Beach, parts of it deal with revitalization and redevelopment of properties, and whether it was a change of zone process or multiple variances for this property, something's going to be required in order for this property to be revitalized and redeveloped. And as the commissioners are aware, and everyone else who's here, part of the revitalization has moved closer to the Route 1 side of things. Of course, Dogfish Head is immediately down the street from here, from this property, and so this would be a continued part of that redevelopment of that area and revitalization of that property. This afternoon's request from Limitless is that the commissioners send a recommendation to the city commissioners recommending that they approve the change of zone request, and that for the portion of the property that is zoned residential, so that the entirety of the property would have one commercial zoning classification. As you can see, in conclusion, I just wanted to address some of the zoning areas that surround the property. Certainly you have R1, which is immediately behind the property. If you're looking at the sort of towards the back of the parking lot. Across the street, you have the VFW, which is owned by the city itself. At the corner, on the opposite corner, you have the Barrister Building, which has law offices. And of course, there are the Scarborough condominiums that are behind where the building is located on the property. The good news about those condominiums, and I think it was referenced at the January 11th meeting, and this would apply regardless of what any redevelopment of the site is, but as you can see, their orientation does not have them looking into this property. Their orientation is more east-west, so the side of those units is what would be immediately facing the rear of 330 Rehoboth Avenue, just as occurs presently and as you can see on the screens. Given the unique nature of the split zone of the property, again, the request from Limitless this afternoon is that a recommendation of approval of one zoning classification be sent to the city commissioners. That concludes my presentation, and I'm happy to answer any questions that the commission may have.
Go for it.
You wanna-
Susan?
No, are we hearing from other members of any presentations?
No, if you've got any
before?
questions directly on the presentation, ask Mr. Hutt now. If we can have him back after we hear from other people. Okay. Rick,
But I think we may have a related question here between the two of
make
us.
sure you speak in your microphone, please.
I think Jeff and I may have a related question here between the two of us, but does the land lease agreement give the tenant the authority to seek a rezoning of the land itself?
Again, I'm not involved in the litigation. I will state that Limitless' position on that is that it does. I suspect that my counsel out there that represents my fellow counsel out there, counselor that represents the plaintiff will take a different position on that.
Jeff, did you have one?
No, that's the standing question.
Okay. Should we read letters in now, or should we hear from the other attorney?
You can do any, I mean, at this point, you know, you're just taking stuff in, so I don't, it's your pleasure, really. And I don't really have a preferred.
We have a number of letters, correspondences, but I think, Lisa, is that Lisa Brown? Is representing Stein the third, whatever. Would you like to take the microphone for a bit?
Either spot's fine, whichever you prefer, yeah.
Identify yourself.
Sure,
and-
thank you. My name is Lisa Brown. I'm with the law firm of Greenberg Traurig. We represent, and for ease of reference, I'll call them JJ Stein in the litigation, which is owned by Diane Stein. And what I want to first start it with is I respectfully disagree with what Mr. Mandela said regarding what you need to consider with the litigation. And this goes directly to the question that was just asked. The underlying litigation is actually seeking a declaration that the ground lease is no longer in effect because of defaults under the lease. And my client is seeking over $2 million because of defaults and breaches of the ground lease. So therefore, I do believe it's a question of standing, because if the court should determine that the ground lease is no longer in effect, whether or not Mr. Lockwood is able to rezone under the ground lease is a moot point, because if the ground lease is no longer in effect, he has no standing to do anything with the property. So I'm not here today to address whether or not the property itself should be rezoned, and no matter who owns it in the future and what they choose to do with it, whether or not a rezoning would be necessary. I'm here on behalf of my client because we can't get there until we determine who properly own, well, we own, but who properly is currently leasing the property. Because if the ground lease is no longer in effect, if that's determined through the litigation, then we could either lease to someone else under another 99-term lease, or perhaps we'll keep the property ourselves and develop it. But at this point, if the ground lease is not in effect, Mr. Lockwood can't do anything with that property, including a rezoning. I understand that the application was made in January. After my client found out about that, my law firm wrote a letter after the meeting. I believe we didn't even find out until after the application was submitted and the meeting was held. We submitted a letter at that point lodging our objection. And again, this lawsuit's been pending since November of 2018. We only found out about the current rezoning application August 1st when Mr. Mandalis let my colleagues know that the application had been submitted. We then found out it had been submitted in June, knowing full well that the litigation was ongoing, and we only found out in August. So again, it may very well be that a rezoning of this property for whatever it holds in the future is the best for the property, but at this point I would submit it's an issue of standing, and we don't believe that at this point, until a court makes a determination otherwise, that Mr. Lockwood has standing to do anything with this property, including a rezoning.
Thank you.
Do you have any questions for me?
Any questions?
So, thank you.
Thank you very much.
Yeah. So you want to take things from the audience now, or you want to read the letters first?
Now let's read the letters first. Glenn, would you just give us a little brief background? Lisa has indicated that there was communication. There was a series of communications between you and their legal firm because they had requested that.
That's right. That's right.
You want to get that into the record, please?
Sure. So when they were here previously, when Mr. Hutt and his client were here previously in January on the site plan review, or the concept review, there was an objection lodged by the plaintiffs to the litigation at that time. And it's Hal Bierman, I guess, at your New York office, right? And he and I corresponded, and I did represent to him that to the extent, because that was just a concept review, they came, you gave comment, and there was nothing thereafter pending before you. So he asked, and I agreed that if anything in addition were filed, I would let them know as a courtesy. So when this application came in, I did let them know, this is my email to him, in fact, of August 1. It says, Hal, when we last communicated, I agreed that if or when any application is made to the City of Rehoboth Beach concerning the property at 330 Rehoboth Avenue, I would inform you. Attached is an application for a change of the zoning designation of the parcel. As you are likely aware, the parcel is split zoned, such that a portion of it is in the commercial district and the other portion has a residential designation. The attached application seeks to have the parcel zoned completely commercial. The application was administratively referred to the Planning Commission for its recommendation to the City Commissioners. The request is on the Planning Commission's August 9 meeting agenda located here, and I gave them a link to the agenda. The meeting is at 3 p.m. in City Hall. So that was the last communication I had, other than I think he wrote back and said thanks, and he would be asking a colleague to come, and Lisa's here because of that communication.
Okay, thank you, Glenn. Any other questions at this point? Let me read in, or have the secretary read in several letters that have occurred, and then we're going to open it up to the public. And I would ask you, by the way, when we do open it up to the public, please address your questions directly to the Planning Commission, and do not address them to either of the attorneys. If there is a need for us to relay the question to the attorneys for comment, we will do that. So we ask you to address us. There have been a number of letters that have been submitted over the last week or so, several today. So I'll ask the secretary to read them in. I guess I don't think I'm not sure that they got attached or embedded in the minutes.
I don't think they're in the agenda. I don't think they are embedded.
Yeah, they came in too late.
Right.
Okay. This was dated August 9th, which is today, obviously. And this is from Tony Zakai, I'm assuming I'm pronouncing that correctly, at 217 Philadelphia Street. Members of the Rehoboth Beach Planning Commission, it is with great concern that I write this letter regarding the potential development of the, this is the Wells Cabin one.
Yeah, that's not relevant.
Yeah, right.
sorry.
Yeah.
Oh, sorry.
Yeah,
Yeah, this is more
Okay,
about, this
Zani.
is more about
there we
mixed
go.
use.
There we go. Okay.
Yeah, it's about mixed use.
All right, let's back up here. All right.
They're just two, from the
Schaefer.
Franks and from Mr.
Schaefer,
Zani.
Schaefer. We have another one. Okay, go ahead. You can read that one.
Is there anyone?
Zani,
Okay.
or-
Yeah, okay, this is from Guido Zani at 235 Country Club Drive, unit number 402, directed, or sent to Ann Womack, subject zoning request. I live at Scarborough Village, which are condos that would be affected by the proposed hotel on the corner of State Road and Rehoboth Avenue. I would like to file my objection to the rezoning of the property on State Road for commercial use. This hotel, with its trash pickup, traffic, and noise, will negatively impact property values for Building 6, which in turn negatively impacts on owner equity for the entire condo community. Guido Orzani, 235 Country Club Drive, Unit 402.
And then there's one that came in actually last night.
Okay. And this one is, again, directed to Ann Womack, subject M. Schaefer Planning Commission meeting. I don't really know what that's about. Anyway, dated August 8th, last night. Ann, would you please forward this email to Chairman Mellon? I could not locate his contact information on the city website. Would you also distribute it in the commissioners and read it into the public record? I will be out of town and unable to attend the hearing in person. Would you also be kind enough to let me know that you received this email? This is Mark G. Schaefer, broker, R&R Commercial Realty, P.O. Box 717, Lewis, Delaware. Okay. Here we go. And this is addressed to Mayor Coons, and it was also copied to Glenn and Dennis Forney of the Cape Gazette. Mayor Coons, I'm addressing this email to you as I did not receive a response from Ms. Lynn to my email below. I was able to receive the answer to my email from city staff. They, by the way, were extremely helpful and courteous. The reason for my question was that I wanted to review the rezoning application for the old Seahorse restaurant property on Rehoboth Avenue, which I read about in the Cape Gazette, and which is on the agenda of the upcoming P&Z meeting. I assume that means planning and zoning meeting for review and action. It appears that there is no application filled along with the required $1,000 fee for this property. I would like to ask how and why the proposal for rezoning is being heard by the P&Z Commission. I believe, parenthetically, I will admit I could not find it, that your ordinance, your rules and regulations and custom is to require any rezoning request be made on your approved form signed by the property owner and accompanied by a $1,000 non-refundable fee. Your staff confirmed that none of these were required by the applicant. Would you please let me know why and by whom these requirements were waived, and if this is now be standard practice for all rezoning matters before the city? It appears that a special accommodation was made by the city for this applicant with no public notice and is inappropriate at the least. I look forward to your response. Thank you for your service. Mark G. Schaefer Sr., R&R Commercial Realty, P.O. Box 717, Lewis, Delaware. Okay. And then this is, that doesn't like pertinent.
And in fact, there, as we mentioned before, there is no application.
Yeah.
And what he probably was referring to was an application for site plan review.
I think
I
that's probably
suspect, I suspect.
Yeah, I think that's probably right. And I spoke with Ann today, who is doing well, by the way, after her eye surgery. And she does not recall a fee being charged in the, several applications that have occurred through the years.
All right, we'll open it up to the audience.
This one here is, I think, for Frank.
Oh, yes, yes, I'm sorry. I thought there was one
One
more.
more.
Yeah, I thought there was
Just
one more.
One more with Fiona. This is the same thing. Okay.
Okay.
All right, this one was dated August 8th, addressed to the Planning Commission, dear Commissioners, regarding proposed Rehoboth Grand Hotel. I've been coming to Rehoboth since 1970, my entire life, and my husband and I are homeowners at Scarborough Village, located at 245 Country Club Drive. We are concerned about the proposed development at the property on the corner of Rehoboth Avenue and State Road and like to voice our opposition to the proposed change in zoning. Obviously, as owners of one of the units adjacent to the property in consideration, we see many negatives that will impact us significantly. These include a loss of view and privacy on the balconies of the units facing this site. In addition, there will be increased noise, trash, and potential rodent problems. And likely there will be a devaluation of our property as a result of the hotel being constructed. Looking at this from a broader perspective, there are other reasons to refrain from allowing the zoning change at the site. First and foremost, it is the fact that changing the zoning in this case sets a bad precedent for future Rehoboth development. While change is inevitable, and I have enjoyed the addition of more shops and restaurants over the years, the speed of growth seems to have become unhealthy, unsustainable, and is starting to negatively impact the Rehoboth experience. We request that you take into consideration the voice of a family who loves and cherishes Little Rehoboth, and that you do not rezone the property or grant variances for the proposed use or allow a 4-story structure to be erected on this property. Rehoboth is a vibrant, ever-evolving town, but its growth must be managed in a considerate way. Thank you for your consideration. John and Jennifer Frink, Building Representative for Building 6, Unit 608, 245, Country Club Drive, Rehoboth Beach.
Thank you.
I think we got them all now.
Now we have them all. Mark? I'll sort of randomly point.
Mark Batchcone, 98 Sussex Street. Could you put back the
Oh, I'm sorry.
illustration?
Yeah.
The nicely colored one. Can I move this so I can go toward it and
I beg your
point at
pardon?
it?
He wants to,
Can
yeah,
this-
remove,
Okay.
yeah.
Do that.
Hang on for a second. Let me get it to you. $61.55.
Wish I had brought some material to work with while I was standing here.
Okay, all right. And which one do you want?
The next one, with the
The colored.
The
the
colored
lots
one?
with the
shaded
color,
This one?
colored lots, yes.
Yep, okay.
All right. What concerns me is we keep talking about the property. Now, it doesn't make sense to me that this would have been one property with given two zonings, a commercial and a residential. So somewhere along the time, this must have become joined as one property. And in fact, if you go to the museum, the Rehoboth Beach Historic Museum, and you look in the, excuse me, Davis Preston Davis collection of aerial photographs, this was wooded, and there were wooden structures here, which means at one time, these were probably separate building lots. And somewhere along the line, they got connected. And we need to find out, go through title searches and the records of the city and the county to find out how this became one property, because I don't think it was at one time. And it may have just become it because somebody built a restaurant and put up a parking lot.
Thank you, Mark.
Thank you.
More hands, please. Let's go over here.
First of all, I had written a letter.
Would you give your name and address, please?
My name is Saurabh Srivastav. I'm at 245 Country Club Drive,
You may want to
Scarborough
move
Village.
that up.
And I had sent a letter in that I've talked to Ann about, which somehow did not find it into your boxes. So if you don't mind, I brought copies. I'd like to.
That's fine. And we can read it in, or you can read it?
Thank you. Thank you.
Thank you.
March? Oh,
I'm sorry.
thanks.
March 29th.
So I take it you're all familiar with where Scarborough Village is located.
Yeah.
I'm the building representative for Building 6, which is the one closest to the parking lot that's being proposed for rezoning. And 6 out of 8 of us have lived there since Scarborough Village was built, which was 36 years ago. And we bought with the assumption that this property behind us was zoned residential, and the worst we could expect was homes over there. So today, when we see this being proposed for commercial use, it's not along the lines of what we were told when we purchased the property. Beside that, and I go back to the Seahorse days, it used to be our favorite restaurant. The parking lot that is paved right now used to be just stone once upon a time, and people used to park there if there was a big crowd to go to the Seahorse. Also, the current use of the building as an office requires very few parking spots, and I believe nobody parks other than overflow parking from Rehoboth. Nobody else parks in that area that works in that building. So if you don't mind, I'd like to tell you what our concerns are. We're a 2-story building with a deck facing the parking lot. And we are actually about 8 feet in elevation below that parking lot. So with the proposed 4-story hotel being built there, there will be the top story will be 2.5 level stories, whatever you want to call it, above us, and it just takes away our privacy. Not only that, this is the west side of the property, and that's where the sun comes in the afternoon. And a lot of people are used to sitting in their balconies in the sun. This is going to block the sun. It's going to block the view, and as I said, the privacy aspect. Some of the other things, we're concerned about the noise that will occur on the adjoining property with trash, with traffic. The original proposal had a restaurant shown. We were concerned about the odors. We're concerned about the trash blowing over. We have had drainage problems from this property all this time, which we have done little things to try to take care of, and it's pretty stable right now. But if this property gets developed properly, we're concerned about what impact that would have on the drainage. We currently have a fence that's about 6 feet high and then some vegetation so it blocks the view of the parking lot for us. That is obviously, at least based on what I think, it'll be disturbed when this property gets developed. And we're concerned about the property devaluation that will occur when this hotel goes there. Also, if you rezone this now, my biggest concern is nothing will keep the developer from proposing more development on this property than the hotel that's currently being proposed. So on behalf of Building 6 and to a large extent on behalf of the entire community, I strongly object to this rezoning.
Thank you.
Thank you. And we will have this embedded.
Okay, thank you.
Thank you. We'll go to the right side this time. Yes, my right. Yeah.
Hi, how are you? My name's Justin Healy. I was a owner over here in J.J. Stein III Inc., and also a tenant with Ocean Atlantic Sotheby's for 14 years in that building. And I just wanted to let you know that when you're looking at this for a zoning change, it's been for the 14 years I was in and the 20 years prior, because I spent tons of time with Mr. Stein learning about the property history. That was always used as a commercial property, whether or not it was allowed to be. The parking lot was always full. I think there's 58 parking spots there. But the whole time we were in there, we're not tenants anymore. We actually assigned our lease to Mr. Lockwood, and we also sold out our partnership interest to Mrs. Stein. But for the 14 years we were there, that was always used as a commercial parking lot. And prior to that, with Chili Billy's and the Seahorse and so on, it was a parking lot that was used quite a bit in a commercial way. So I just wanted to come here in support, but also let you know the entire time we were there, which was 14 years, which is a while, it was used as a commercial, in a commercial way. And I also think when you go over the survey, at least the survey that Jay had when we bought into the partnership, the commercial actually went a bit down, because we originally had, with the Steins, the intention to develop this parcel, and we didn't, but that was the intention. We had looked at the idea of whether it was going to be a commercial retail on the first floor and commercial office space on the second floor. But when we were determining that with our engineers, the commercial actually came over a little bit. This map is a little bit different than the survey that we had. But anyway, I just wanted to share my support and let you know what it was used as the entire time I was there.
Thank you.
Thanks.
Any questions?
Anybody else?
Gary? We'll come back to the left shortly.
Right, Gary Glass, 105 Country Club Drive. So I have some concerns. First of all, I think it's the cart before the horse. I think they need to probably settle the litigation before they come here and ask for a major change in our zoning. Second of all, when we did the 2010 CDP, there was a lot of zoning issues that were taken up, and there was a lot of changes that were made. And then that CDP was ratified and passed on to the state legislature, who approved that CDP plan in 2010. That CDP plan defined the commercial area as we see it here today. There were other people that were concerned and upset with that change, such as the Canal Side Inn, when they changed that. And so I believe we need to respect the CDP plan and the will of the people and the change of the zoning and the use of land in our community. There's a lot of people that are going to be affected when you change any type of use. And Canal Side Inn certainly got affected, and this piece of property here got affected. The parking lot was grandfathered in, and I believe it can be used as a parking lot for as long as they continue to use it as a parking lot. I believe that grandfathering does not last forever, and the way it was used for 20 years isn't relative to the fact that we want to change the way it's being used in the future. And I thought that the way you do that is when you change the use of the property, you have to bring that piece of property into conformance with the way we've now changed our laws. That's a nice line that goes down defining the commercial zone. People buy property around that parking lot based on the way that parking lot is zoned, with the expectation that at some point it will probably revert back to being residential. They didn't buy property around that piece of property with the idea from 2010 that that property was going to become commercial. And so I get it, it's connected to the property, it would be nice, they would like to use it, they can make a lot more money with it, but I think we need to respect the community here once again, and not just the property owner, and understand that in 2010, we rezoned the community as a whole, and we ratified that, and we sent it to the state legislature, and everybody agreed. So that's my first point. And my second point is that I really think we need to pay attention to the residents around that property and their property values, because there is an implied expectation on this map that that property, when it changes use, will go back to being residential. Thank you.
Thank you, Gary.
My name is John McMahon, and I'm 604 Scarborough Village.
You want to tilt the microphone over a little bit? Thank you.
And really, I just want to reiterate everything that Sarb said, but now I want to reiterate everything that Gary said, because we're asking you to buy a pig in a poke. We don't even know who owns this property. We don't know who can do what with it. And whoever your friends are that sent it down to you, they're not your friends. They certainly are not your friends, because this should not be decided here until all the legalities are settled. And I heard that's not going to be till 2020. With respect to this property, we bought ours originally from Bill Vernon. And I can tell you, he stated that property is residential, and if you can expect anything, you can expect it to be housing, period. And that's 35, 36 years ago. Thank you very much.
Anyone else? Yes.
My name is Lynn Srivastava. I live in 605 Scarborough Village. My husband has pretty much represented our feelings together, but I wanted to comment on the lawyer's comment when he said the good news is that it does not affect the front of Scarborough Village. And I need to reiterate that it does impact us. It is the front of our building. It is our deck that faces the construction. So I just wanted to set the record clear that it's not good news, it's bad news. Thank you.
Anyone else? If not, we will close the public comments for now and turn it back to the Planning Commission for questions. Or Joyce? Susan?
Yeah, I actually have a number of things. Mr.
Speak
Huddy-
into your microphone.
Okay, yeah.
Please.
Glenn had talked about whatever, change we recommend being consistent with the CDP, and Mr. Hudd had talked about the CDP, talking about revitalization of the commercial areas and how some of that is moving closer to Route 1. But my recollection of the CDP in terms of specific revitalization was for Baltimore and Wilmington Avenues, and at least in the 2010 CDP, it doesn't address that part of Rehoboth Avenue. Instead, what it says is that managing change will require developing a new attitude toward the benefits of urban planning and an expanded capacity to perform urban planning within city government, and that should occur not once every 5 years, but it should occur on a daily basis. This part of town has been the subject of several applications recently, including the Clear Space Theater, and in those discussions, we have talked up here about the possibility of that part of town you know, becoming an arts district, for instance. That's one of the concepts that have been talked about. But certainly what we've talked about is planning that end of town for growth. So in my mind, that comes first, and perhaps one of the advantages to everyone that this court case, I guess, won't be decided until October 2020, is that by that point, the 2020 plan should be done. And I think we should incorporate whatever we see as the vision for that end of town into the 2020 comprehensive plan, so that then whatever development does happen there is consistent with that plan, since it was not addressed in 2010. So that's sort of my CDP reaction to it. But the other thing I will have to tell you that's given me pause since day one on this is, and Glenn, you had mentioned that there were several rezonings in the last 4 or 5 years. I'd be curious what some of those were, because I'm thinking back to some fairly big ones that have been done over the last 15 years. And in 2000, there are 3 of them that I'm thinking about. That I think are relevant. In 2003, the end of Columbia Avenue and where Grove Street was rezoned. It was 8 lots or 10 lots? The Burton property was rezoned from commercial to residential, and obviously today are these new houses. Those new houses have all been built there. It looks great. Then in 2006, all of Sussex Street was rezoned from commercial to R2. And then Gary mentioned in 2010, when the Oak Grove development was done, that area now where those Oak Grove houses are was rezoned from commercial to R2 as well. So those 3 examples are all properties that went from commercial to residential. In other words, we have a history here of downzoning. We don't have a history here that I know of, and I'd love to be correct if I'm wrong, I don't know of an example where we've gone the other way. And if there's a reason to do that in the future, well, we have to consider it, but it should make us think, I mean, what do we want? Because we don't have a history of ever having done that.
I think the other, the Truett property was
Right.
commercial, but they went residential.
Right.
No,
Because-
well, no.
well, they didn't
no,
rezone
no. Let me,
They
that's
only-
the one other recent one, is the Truett property on Scarborough, I believe it's Scarborough Extended. When Mr. Truett asked there was a subdivision and realignment of the lots, which were zoned commercial. And he was asked, his intention was to try and build residential homes. And when he was asked, do you want to rezone this, he declined that for the reason that he didn't know if he could sell residential homes. So he wanted to leave his options open. Since that time, he has built residential homes. And so the same kind of argument that applied to the Grove, 6th Street, whatever the other streets are, thinking where basically the community had evolved to a point where it was residential. The logic was to make it residential. So that was sort of the logic, both in Oak Grove and here, and actually on Sussex Street too.
Right, okay.
Speak into the microphone, please, Joyce.
On the other side of the street, the red, what is there now?
That's the VFW,
Oh, that's the VFW. Okay, thank you.
which is a city property. Mr. Hutt, I have a question for you. Glenn, of course, cautioned us that we really should disregard the proposal that was made in January, but you kept bringing it up. We didn't bring it up, you brought it up. You referred to it a number of times. The logic is if you were to get a rezoning, okay, let's assume if that happened, tell me a little bit about what the next step would be. I mean, do you have plans? Would it be a site plan? What would be the next step?
Certainly, that's the land use process in any application is you start with the zoning of the property and you move forward from there and see what the permitted uses are and what you're going to do moving forward. One concept has been presented to you and that could be the concept that gets moved forward with modifications based upon Mr. Molina's responses and the responses that were received from the commission members in January. But certainly, I mean, there is, and that I think was the caution that Mr. Mandalis had and that I had in my opening comments is there are lots of many permitted uses in the C1 commercial zoning district. And so certainly one of those potential uses is the hotel that you saw, but that's simply one concept and one idea. I mean, you've heard a number of references to the other uses that the building has been throughout his, whether it's a restaurant or an office. Mr. Healy commented on some of the plans that they had with sort of mixed-use building with office space on top and shops on the bottom. So there have been many concepts over the years, I think, for this. And certainly right now, the one that, and you saw the presentation in January, so certainly Mr. Lockwood has some money invested in the plans that you saw and the renderings and all that for a hotel. So that would, at the moment, that would seem like the next logical process would be to tweak that based upon the responses from the commission and Mr. Molina. But I mean, that would be my guess as to the next steps in the process at this time.
The reason I asked that question is that ultimately, okay, and I don't mean to get outside our directives today, but ultimately, you've got to, with this amount of property, you've got to come before the Planning Commission for a site plan review.
Certainly.
Certainly? Have you filled out an application recently for a site plan review?
Yes.
You have. And would you recall what item 4 is in the site plan review?
I do not recall what item 4 is.
Item 4 in the site plan review, I'll read it to you. I would put it up there. But item 4 says, we are the owners of the property that is the subject of the site plan review application and hereby consent to the site plan review of the project described herein. So my question to you is, with this litigation going on, what's the likelihood that you will get the approval of the property owners to sign this off? Item 3, by the way, is the signature of the applicant. But item 4 requires the owner of the property to approve of the site plan review. And I guess my question is, yes, that's sort of the cart before the horse, I guess it would be the right way to say it. But ultimately, if that's the direction you go, you've got to get their approval. And what are the chances of that happening while you're still in litigation? I guess maybe that's a question that nobody can answer, but.
Certainly, I can't answer what the likelihood is that Ms. Brown's client signs that application. I mean, I certainly can't answer that question.
I can't say for sure without speaking to them, but I can say the likelihood is very low that they would be willing to sign that.
Yeah. So we could be in a position having, if the commissioners chose, if we recommended, or whether we recommend or not, the commissioners choose to rezone the property, it could be a stymie point for further development until the litigation is solved.
Certainly, that's within the realm of possibility. And certainly, you can see that even the process from our January meeting till the June letter took time. And then from the filing of that letter to today's meeting took time. Certainly, the Board of Commissioners, the City Commissioners have not considered this yet, so that will be another additional time period. And there has been no, even at the concept plan review stage, there was no final engineering that wasn't, I mean, I say all that to say, the purpose of today is not to have a site plan for a hotel.
No, understand,
And
we
so
agree.
we're miles away from that point of the land use process. Yeah. And so there could be the natural time that's involved in that could be resolved through the litigation. The litigation may have resolved itself through that, and certainly, obviously anything that, all the money that Mr. Lockwood and his entity puts into something, if the litigation doesn't break his way, then there's nothing that he has to gain for that. But that process in itself And I think that's the process that was referred to in some of the letters of correspondence. I think that people were concerned that there was some form that required the property owner to sign off on a change of zone request, which is not the case, which is why the letter was filed. And again, there's no application fee. There was no special treatment for limitless at any point in
For a
time.
zoning change.
Right, for a zoning change.
Yeah.
And this is not a site plan. And so that's where the process is. And again, as far as to, what the task is this afternoon for the commissioners is whether or not it's appropriate for this property to have one single zoning classification, commercial zoning classification. Wading into the litigation is not, I'm thankful I don't have to wade into the litigation. And the good news is that the Planning Commission doesn't have to wade into that litigation. Mr. Mandalis indicated the city commissioners may. That was his opening comments. But at this point, it's a recommendation on a land use question, not the ultimate legislative action that's involved in the city commissioners deciding whether or not to change the zoning classification for part of this property.
Just from, I'll put on the Planning Commission hat at this point, but it would appear to me that from a planning standpoint, because what we've heard proposed, and we understand there's no commitment to that proposal, represents a significant increase in population and perhaps car density for that area. And we've seen the same thing, let's say, with clear space. And so I think one of the things that we have to think about, because we have to look at the impact of development, in this case, this particular piece of property, and what's the impact in the general sense on the community, and is that what the community wants, is an increase of density with everything that goes along with it, okay? And so that's something that, and I guess I would, sort of going along with what Susan had said, is that perhaps this is the kind of thing that needs more study relative to the total holistic approach of what the CDP may say in terms of development, rather than on a piece-by-piece basis. So,
And the good thing about that is we have the opportunity to do just that, because the case is not going to be resolved until October of 2020, and the plan is going to be done before that, presumably.
so
Yeah.
And certainly some uses and I think we discussed this in January, but some uses have parking built in and some do not.
Yep.
The potential hotel concept has parking required. There are certainly other commercial uses that do not require parking. So the planning, obviously in looking at that, is look at the full gamut of potential uses and planning. And certainly the focus of the 2010 CDP was certainly the first two blocks. I mean, it certainly talks about the first two blocks. There's really nothing directly, other than I would say, it says it's supposed to be done on a daily basis, and it's what we're doing. So there's I would agree wholeheartedly that there's no directive with respect, like there was with Wilmington and Baltimore, and the first two ocean blocks, as there is here. But certainly the natural flow of this, as you're driving down Rehoboth Avenue, you can see that is the expansion of the commercial opportunity has moved right basically to this property's doorstep. Across the street, of course, had clear space. But that's certainly the question. But the other thing that we heard this afternoon was that when people purchase their lots, that they assume that would be residential. It has a 60-year history of being used in a commercial fashion and not a residential fashion. And so that might be the hope that in some much broader, longer view, that at some point in time that becomes a residential use, but that is certainly not the known history of the use of that property. And I would agree with the gentleman, I think it was Mark, and I apologize, I didn't
Betchkel, Mr. Betchkel.
his last name, when he said that most likely what happened is the building was built and then the wooded area slowly the woods were, you know, people, the business got more busy, or busier rather, and needed more parking, so trees came down and people parked. And that was probably the evolution of it, but you have a 60-year history of a non-conforming use of that fashion. And certainly the parking lot changed over time. It became stone, and then it became the asphalt that is there and with all the various parking places. But that is the history of that property, and what one would anticipate would be the continued history, would be some sort of commercial use that, and if it's one that requires parking, that as has been done for the last 60+ years, would be the parking area for that business. And that sort of leads back to the point of, if that's going to occur, does that occur through a change of zone so that the whole property is one zoning classification, or through a multitude of variance requests to the Board of Adjustment to try to work through that and carve out exceptions wherever exceptions can be carved out, and variances for various things.
I think you made a statement earlier that speaking to having it as one zone is that certain uses of the property, if it remained residential, were essentially illegal. I think you made some statement relative to that.
Certainly, you can certainly compare the list of permitted uses in the R1 residential zone to the C1 and see that the list is obviously, I think there's one permitted use in the residential use areas.
I just wonder if there should be a quid pro quo, because we have within the residential areas of the city, we have businesses that are being run as investment properties. So perhaps what you've suggested is that they should not be there because they're not zoned correctly.
I don't think that's the suggestion that I have made.
No, I made the suggestion.
Oh, I was gonna say,
I'm just.
renting somebody's property
It's
is
just a
not
bit of
typically a commercial
circular
enterprise, but-
logic based on what you said.
No,
Okay.
I don't think that argument follows, but
We can argue about that.
we can.
Okay, thank you.
Can I ask for a clarification on something that was brought up earlier about whether the use is currently grandfathered, and if there's a change in use, then what?
Grandfathering goes away.
Yeah, that's what I thought. Okay.
Isn't that
So-
correct?
Yeah.
Glenn?
Okay.
Generally, if there is a change of use,
So, okay.
Similar use,
Okay.
continue, unless it's a similar use.
unless it's the same use, yeah, the grandfathering goes away.
Okay. But this would not be considered a similar use, the hotel? And all of that, right, okay, right. And so it's been a restaurant, so, okay.
Yeah.
So it starts over, basically.
It starts open.
Yeah. Okay. So I just wanted to clarify that. Mark?
Yeah, and I also wanted to react to that. I was thinking the same thing that Susan was just thinking about the grandfather part, because my understanding was, with development, it has to change. But I think the standing issue is relevant to what we're discussing today. I mean, in my opinion, it's enough for us to make a decision that since we know the standing is going to be resolved in 2020, we would have a better idea at that point what the development will be, not the specific building or anything, but what the commercial use would be. And I think we're not ripe to make a decision today, because there's no, other than it would be nice for some owner, maybe not another owner, if it was joined or not. There's really no compelling reason to take an action today. We have almost 15 residential owners that abut the property, and we've heard testimony from a sample of them that would lead me to believe that there's going to be almost 15 objections to a commercial use. And the non-conforming nature of the lot now minimally impacts the residents. A rezoning could really impact the residents in all kinds of ways that we can't predict, because of the litigation and the standing and how that's going to all be resolved. So I think we should just set the clock back to after the litigation is settled, and then let's hear the development proposal and decide if it's in the best interests of the community and it fits the CDP.
I completely agree with Jeff. And I just don't think that this is ripe for the Planning Commission to consider. Like the chairman, I spent a couple of hours searching through our code, looking for, how one goes about seeking a zoning change, and found nothing of any help whatsoever. And obviously, that's something we should be thinking about addressing. As a lawyer, I'm very troubled by the standing issue, along with Jeff, because I think there is a determination that needs to be made, and in the absence of a clear code provision that would suggest that even a tenant could request a zoning change without the owner of the property's consent is bothersome to me. I would analogize it to me leasing my home to someone and having them apply to rezone my property that I still own from residential to commercial. And that, it just boggles my mind. That just can't be, it just can't make sense. And from a legal perspective and the property owner's rights, it doesn't make any sense. And in the absence of a clear provision in a lease that gives the leaseholder that right, and the owner has consented to that in advance, I just don't think this process should even move forward at this point.
David, I agree with both of them. I think it's, I think if we went forward with something, it could certainly be argued in any court who has the right to change the zoning at this point. And the idea of looking at that whole area as a whole, including clear spaces, application, et cetera, what's going to happen at that end and around the circle and all the problems we have. I just don't think we can look at anything in an isolated way. I think it has to be, as Susan said, in a much more holistic view of some guidance for what's going on there. And I think to change that, even if it were legitimate, without knowing what's going to go there, to change that from residential with all the property owners backing onto that, I think is irresponsible on our part. I think we need to wait, get feet in, and have the proper information before we move on all fronts.
I'm actually wondering something. There's no process, you said, in the code. There's no process in the code for rezoning application, and there's nothing. Is it because they've all been done in conjunction with formal site plan applications that do have a process? Is that, they haven't? Okay.
I don't know that it's because of that. The ones I can think of have been in conjunction with, I guess I can think of one years ago. There was a split zone property. In fact, Gene Byard with your firm, I believe, brought the application. It was another split zone property. I can't recall where it was, but it was a standalone application outside of any kind of site plan. I think it was even before site plan review existed.
Yeah.
But our code is unique in that it does not have a process to initiate a zoning change. Most other codes that I can think of and recall in my mind right now have very specific ways that you initiate a change.
Can I just ask, on the Burton property, when that went from commercial to residential in 2003? The Burtons were against that, against that zoning change. Who brought that around? Was it the city? That was complicated. They all stood up at that meeting. Oh, that was before your time?
Yeah, and the Sussex rezoning was just when I was coming on, and there were owners along Sussex Street who were.
Harvey would know.
That was in the CDP, so it had to be done within 18 months. CDP said it was going to be proposed for rezoning, and the city proposed.
Okay, all right, thank you.
That was the 2004 CDP, probably? You okay? Okay.
Right.
Yeah.
Harvey, if Ann was here, she'd ask you to come to the mic. You realize if she was here, she'd.
Harvey is our source of all information.
Thank you, Harvey.
Thank you, Harvey.
So do we have to take any action today if
Well, we
we
have
just
to
say
vote.
we're not going to take any action?
I'll add one thing to the discussion just because I'm sitting here thinking about it, and it's going to sound somewhat, take a different slant than what, there's the perspective that I've heard on both ends of the table, and here's what it is. Imagine, for example, if you had a industrial zoning district, and many people bought those properties, and they all built individual single-family dwellings. And the neighborhood started to grow up as it was all single-family developments or single-family homes, but it's all still zoned industrial. The Board of Commissioners didn't move quick enough to change the zoning to catch up with what the neighborhood has. I'm sure that if I lived in one of those homes, I would probably be coming to and somebody brought an application, said I want to do an asphalt plant or whatever in this industrial location because it's permitted. I'm sure that as an owner, I would come to the Board of Commissioners and say, please change the zoning on the property next to me so that it doesn't happen again with any of the other. So I personally don't take a lot of offense to somebody who, other than the owner requesting that you all look at a change in zone. It does seem hostile. I agree that it does seem hostile. But when you do the comprehensive development plan, for example, you all solicit people to come in and say, well, what should we zone in that part of the town? What should we do in this part of town? So it's not unheard of for a planning commission or a board of commissioners to hear from people who don't actually own the property as to how the property should be zoned. So it's different than an application to build something on the property, which then I think, standing issues become a little bit more relevant. But just as a matter, because remember, your job is conceptually, what is the best zoning for this property? And if somebody brings you an application and says, there's a better zoning for that property that you haven't thought of, your job is to consider whether, in my view, your job is to say, what is the best zoning for this property as a matter of health, welfare, and safety of the entire city? Remember, the zoning district, the zoning plan is to address the development of land throughout the city. So if somebody were to say, even across town were to say, have you thought about this property being that particular zoning? And maybe it's a wonderful idea. We might be thinking about it a different way. So I just add that for what it's worth.
Glenn, I think I might take issue.
You can.
With part of what you're saying.
Everybody's taking issue today with me, so it's okay.
You started out by using the example that you had homeowners who built in a commercially zoned industrial area and the homeowners seeking to have it rezoned for residential. They weren't leaseholders seeking to rezone the entire area as residential. And so I do think there's a difference between a property owner and a leaseholder. And I agree with you that we have an overall obligation to make determinations and suggestions in terms of how the city develops. But we should be looking at that from an overall perspective and not a parcel by parcel perspective, in my view. And so while we may at some point, in the CDP, for example, conclude that the western portion of Rehoboth Avenue should be, should have an arts district overlay zoning or something along those lines, that's a lot different than simply saying, that one party can come in and seek to upzone from residential to commercial, even though there has been a history of commercial use. I don't think this is a situation of adverse possession and things of that nature. It's just the city has been lax, I think, in enforcing its own code. And so that's really, where I take issue with your analysis and how we could approach it. When I think about the provisions in the code with respect to partitioning and, unmerging properties and things of that nature, and is there, a non-conforming use on the parcel you know, can that be used for anything else? And as I understand the code, you can only change the use of that nonconformance to something more restrictive. And I think one would generally argue that a residential is more restrictive than commercial. And so I'm analogizing to what I think is already in our code with respect to the use of non-conforming uses of property and what you're permitted to do. And I don't think it's upzoning. It's my 2 cents.
You know, in answer to Glenn, or to further the discussion with Glenn, I think probably the closest analogy is the Oak Grove area, where that was commercial. And at the time, but it had evolved to essentially residential, both single-family homes and some either condos or multi-family dwellings. And my recollection is that at the time that the question came up, basically the people had that same argument. They wanted to assure themselves that the nature of their area, their property, could not change because it had been developed. It wasn't that there was a bunch of empty lots and they were worried about what might be built. It was already built. And there were only my recollection, two commercial buildings in that whole area. One was Kirchhoff's Canal Side Inn, and the other one was the antique shop. And the antique shop, they didn't want to change their business, but they agreed that if they could remain grandfathered as long as they lived there, then they really didn't care if it reverted. Kirchhoff had a different position because he wasn't sure that the inn was the right thing to do. He didn't know if he could make money, and he wanted the flexibility of making it something else. So he was the prime objector to changing. But I think most of the people in that area basically wanted to protect themselves against all of a sudden somebody saying, I'm going to run a gas station out of my house, or do something, run a business with a bunch of trucks in front, et cetera. So this issue, I personally think, as my colleagues do, is that it's worthy of delaying the decision. I think there is an issue of standing. It's not that they can't apply. We recognize and accept the fact that almost anybody can probably apply for a change of zoning. But it seems to me that when the owner of the property hasn't got a say, that bothers me.
Because all offers, they do have a say. They come here and they talk to you and
Well,
say,
yeah.
I mean, they have a say. So, but I hear.
Do we have a motion or a
It
consensus?
seems to me as though our recommendation back to the Board of Commissioners is exactly what you said, that we believe that we should delay consideration. Because of for me, I'm basing it on the issue of standing, and Jeff and I had just talked about that as we were starting this deliberation, and I feel that's fairly important from a legal perspective. And I'm not making I'm not making my decision on delaying this based at all on whether or not I think a C1 rezoning is more appropriate for that parcel of land or not. I mean, that's something that I think we should consider down the road at the appropriate time. I just don't think with this standing issue out there that this is the appropriate time for us or frankly for the Board of Commissioners.
How do we handle this?
Well, I mean, there's a few things you can do. If you're sort of in agreement, there would be a recommendation to not change the zone.
Right.
At this time.
Do we need a vote?
I think you do. I think you need to send something back to them, whether it be don't change the zone with some clarification that the reason we're saying not change the zone is because we don't think, because you all don't believe that it's appropriate to do it at this time, not based upon the merits of the request, but based upon the procedural posture of it.
That's exactly what I think I have in mind. Yeah.
Would you like to make a motion that we do that?
So moved? Or do you want me to state the motion?
I prefer if you said
Okay.
something.
I move that we recommend to the Board of Commissioners that consideration of the rezoning of parcel 330 on State Road be delayed inasmuch as there is a question of standing. Provided, however, that the Planning Commission is not making any recommendation one way or the other on the merits of any rezoning request.
I'd second that.
We have a motion as stated and second. Any discussion? Can we have a vote? Let me start at the right-hand side. Joyce? I agree, yes. Susan?
Aye.
I
Jeffrey?
agree.
Aye.
Aye.
And the chair votes aye
And I'll just say, for those reasons, I say aye.
for those reasons. Yes. Okay. Thank you. Mr.
At
Hutt?
least I hope to stay down at the beach for a while and enjoy what we have here. Good, good.
Not an easy one.
No.
Moving on.
Jessica is here in the back of the room. Thank you for being patient with us, Jessica.
I'm looking for an agenda.
Thank you for coming.
Yeah, thank you.
Yeah, absolutely. Yeah, see.
Yeah, we have and then she's here.
She's here. She's been here for a while.
Sorry, Jessica.
You got to hear most of this.
We have our only other piece of business is a presentation by Jessica. Have you got anything to put up, or you don't have a slide?
I did not bring one.
Okay. The issue came up, I forget exactly how it came about, but we learned of some rule changes within the Sussex County Conservancy District that might have an impact on how we subdivide land, or at least, well, how we subdivide and develop land. So we thought we would have a little discussion with you today, and you could enlighten us whether those changes, how they impact us, and et cetera. Okay?
Okay.
And part of the reason it came up is because we do have some big projects that have been proposed that are over the 5,000 square feet. You know, they're large commercial projects, and we didn't know where in the process the applicant would come to you versus where they are within site plan review. So that's one big issue, and the other issue was the 5,000 square foot lot for homes that are built as well.
Okay.
Yeah, and let me just clarify that a little bit. In general, when we've had issues that have been handled by the Conservancy, Oak Grove was the one that comes to mind, very large project. Basically, my understanding is you folks really didn't want to make any decision relative to Oak Grove and layout until, in fact, it was subdivided. And in fact, my recollection, and maybe Harvey can help us with that, is until we even decided, or it was decided by the owners, where the houses would be and what basically the nature of the land would be. And that is a perplexing problem for the site plan review process or the subdivision review process, because the Planning Commission would like to make decisions and in some cases conditions, set conditions, and yet we don't know how you're going to respond. So
Okay.
if you could sort of address the timing issue and what's involved.
All right. Before we look at this, I'll address kind of the timing issue. Our regulations do not stipulate when a plan has to be submitted.
Use your microphone.
Okay, so our regulations do not stipulate when the plan has to be submitted to the Conservation District. So typically what happens is once a project goes through a preliminary review with Sussex County, it then, the engineer then proceeds further with the design of the project, and they'll have pre-application meetings with us, and they'll design the project following preliminary approval. I'm not sure the language, the terminology of when things are submitted to you guys. But usually, I would think that they're not going to submit to us until they've received concurrence from the town, from the municipality, if that makes sense.
Which is at the end of the process.
Okay.
for us.
So most of the time, until they receive that preliminary approval that, yes, we concur, you can have these many houses or the setbacks, then that engineer typically, he invests his time in completing the sediment and stormwater design, and that takes quite a bit of time too. So that's typically when we see plans. They can submit to us prior to receiving preliminary approval. However, that's kind of at their own risk because they may be re-engineering that project depending on what the comments are from the county or the municipality.
Typically, how long does it take you, the Conservancy, to reply to an application?
We have 30 days to review the project, and we generate comments in that to the design engineer, and then they resubmit. Typically, on average, it's about 3 reviews in order to obtain approval, kind of depending on the complexity of the project.
Okay. Tell us about the rules, the new rules.
Okay, all right, very good. So the handout that I brought today is just very brief, but just gives you just information as to when our regulations came about, which was 1991, requires all land disturbing activities of 5,000 square feet or more to have permit coverage. And that can be from constructing a single family residence to subdivision to any commercial project. So anything that disturbs 5,000 square feet has a plan associated with that activity. Our project, we are delegated responsibility from DENREC, so they do oversee our program. And then if you flip into the next page, so the state and federal requirements, this just kind of goes into what we're permitting, which is the components of a plan are sediment and erosion control and stormwater management. So depending on what that activity is, we do have some minimal earth disturbance projects, which is like your single family house construction, and that would just be sediment and erosion control. And then when you have a development, a residential project, you are going to have stormwater management associated with that design. So I kind of started off with the standard plans because I thought that was something you guys would maybe want to talk about. A standard plan, so there's 2 different ways to permit a project through the Conservation District if you are going to disturb 5,000 square feet or more. The easy way, the first step, is a standard plan. Those are for what we call minimal earth disturbance projects. So that would be a residential project. Non-residential can qualify, tax ditch maintenance, utility projects, agriculture structures, poultry house construction, demolition. So these are all things that are going to exceed that 5,000 square feet. However, really the construction activity is minimal. There's not going to be much new impervious cover created, and there's conditions with those permits. So,
Just a quick question.
Sure.
Up above, it says greater than 5,000, but you've said 5,000 or greater. Which is it? Because our minimum size lot is 5,000 square feet.
Yeah, so it's 5,000 square feet or greater.
Or greater.
Yes, is what you're going to have to submit a plan for.
Okay. And when you say disturbance,
What does that mean?
yeah, what if the whole lot, it's defined disturbance,
Okay.
how much of the
my
lot gets
question from-
disturbed?
And that's a very good question because we get that pretty often. They're like, well, my house is only 2,000 square feet. Well, really, to construct that house, you are going to disturb, a good portion of that lot, for the construction driveway, the garage, any kind of grading around the house, septic system, if they have one. All of that is considered earth disturbance. So any earth that is disturbed in that construction activity is considered earth disturbance.
So if there's final grading,
That's included.
that's included. So,
Yeah.
so basically, it is the entire lot size.
For most of the time, it's the entire lot size. We've had some projects come to us. I'll just in Rehoboth, where they said, well, I had to protect this tree here, and this was 20 square feet, so I did not exceed the 5,000 square feet. So, and I'm going to put my, orange tree protection fence up.
Yes,
And
that
so
happens a lot.
they were exempt.
Okay.
So we have had those cases.
Which is why I think we're changing, and Dom, you all are working on something to, or was Kevin telling me we're working on something where we're,
I think it's more of among the commissioners to discussing the extent of disturbance.
Right.
I agree that 5,000 is by the state, but I think that the city may also consider a percentage of the lot disturbance.
Right, because the number I was hearing was 2,500. Because that would then encompass any new construction, whereas there's an argument to be made that it wouldn't be disturbing it if it was left at 5,000. So that,
I don't think there's any prohibition of making stricter requirements.
no, not at all.
Other than, and I don't know if Jessica, this conversation's been had with Jessica yet, so we're premature at this point. She may not want 2,500 square foot plans coming to her
Well,
office.
okay,
So,
yeah,
I mean, that's
Yeah.
a conversation we're gonna have to have
Yeah,
with
right.
the conservation.
Okay.
Sorry,
Yeah.
go ahead.
No, sure. So just going through this information that I submitted, I just, the next page is residential standard plans. And that's just to clarify the information that we require in order for an applicant to receive a residential standard plan. So they're basically doing what's called sediment and erosion control. So best management construction practices while that lot is being disturbed. This is all online, so if you can't see this clearly, I did put a link on here so that you could view that information. So there's 2 permits. Let's just use residential, for example, because that's the one I think you guys were interested in. For a residential project that is less than 1 acre disturbed, they're basically putting up silt fence, a stone construction entrance. There is nothing that stipulates, the impervious cover with that lot. They're only required to stabilize all areas that they've disturbed once the construction activity is completed. The other one, residential, which I don't think will be applicable here in the city of Rehoboth, but lots that are greater than 1 acre, there is a condition with forestry. And that's really the only difference between the two, is making sure that they preserve a certain amount of trees. But again, there's no condition on maximum impervious cover.
Do you specify in terms of the topography, what is acceptable, what is not acceptable? In terms of runoff, because obviously the concern would be runoff from a developed piece of property into an adjacent piece of property, or in fact into the street, or what have you. And is there qualifications on that?
No. So, and that's a very good question, because that's some of the drainage complaints that we've received from residents. For instance, if a small home was demoed and then a larger home was put in its place, most of the time they're elevated. But there's no conditions on where those downspouts are directed, how their lot is graded. So then we'll receive complaints from neighboring properties saying, hey, my neighbor just built this large home, all of their runoff is now impacting my property. Fortunately, there's no grading lines and grades requirement associated with this residential standard plan. So the county, about 2 years ago, adopted a lines and grades requirement, and some municipalities have that as well, and that may be something that, you guys may want to investigate if you haven't already.
We could impose that kind of restriction.
Correct.
Do you define what constitutes impervious surfaces or pervious?
So the impervious surfaces would be the roof runoff, the driveway, any kind of patio, sidewalk, all of that would be, any of those hard surfaces would be considered impervious.
Well, I guess my question then would be what is considered a hard surface?
A hard surface?
I mean, is it gravel or is it concrete?
Oh,
I mean,
so the difference between, well, we do still consider gravel impervious. At some point, that gravel may become, an asphalt driveway. So that, to us, is still considered impervious.
I mean, is there anywhere where you have a list of these types of products, are okay, they're deemed to be impervious, and these aren't?
Really, I mean, for us, the pervious is really just going to be your grass and woods, those conditions. Now, when we do stormwater, when there's a stormwater analysis, there are very detailed numbers. Like gravel would get a different number, meadow, grass, agriculture. So it's detailed in that regard. But for this application for a residential standard plan, we don't look at it that way.
Thank you.
Sure. Okay. Yes.
Sorry to interrupt again. Sometimes if there's a demolition of an existing property or on an existing property, that property will sit idle for some period of time before development. the city requires that it be graded and treated in a certain way. Do you get involved in looking at the property under those conditions? It really has been disturbed. You've torn something down, but it isn't in its final state. How do you get involved in that, or do you?
Well, if they're going to disturb 5,000 square feet, then they are supposed to get a demolition permit. When they demo, the permit requires that they stabilize the lot once complete, but again, we don't get into any kind of grading of the lot.
Okay.
So, the residential standard plan for ease of permitting can be completed at our office, or there's an online application. And really the intent of the standard plan is to make builders, property owners aware that they are required to install silt fence, that they need to comply with the conditions of this permit. So it is a $100 fee. And I just included a detail of what they receive, which shows the silt fence around the lot. So this one picture is the criteria where silt fence should be installed, a stone construction entrance so that they minimize tracking on any roadways. And then the construction notes detail stabilization and best management practices. So this would also be similar procedures for what we call minimal earth disturbance activities for non-residential standard plans, and that would be your commercial projects. In some cases, if it's already an impervious lot, like for here in Rehoboth, so if there was an impervious half-acre parcel that wanted to be redeveloped, they could potentially qualify for a non-residential standard plan because there's no net increase in impervious cover.
So the hotels we're looking at would fall into that category, right, too?
Possibly.
Yeah.
They were right there
Yeah.
on the acre. So
Well, they're
there's-
less than.
Yeah, so there's the potential that they wouldn't have to do stormwater management if they were able to demonstrate the compliance with this non-residential standard plan, the conditions of the permit.
So this means they don't have to submit a plan?
They have to submit a plan because they're going to be disturbing over 5,000 square feet, but that plan would only be for sediment and erosion control. They would not be doing any kind of quantity or quality treatment of the runoff because they're going from impervious to impervious. And there's basically no change in the runoff.
We recently had, on Route 1 in the Forgotten Mile, the service station, or it's really a repair, auto repair
Yes.
place, which tore down an existing building, put up two fairly large buildings.
Right.
Okay, did they go through this process?
They did. They received a non-residential standard plan. They had no net increase in impervious cover, so there's basically no change in the watershed. So they applied and received a non-residential standard plan.
And yet we've heard that their water sheds off their property into adjacent properties.
I had heard the same thing, but there was no net increase. And from our inspection, a lot of that water, or portion of that water, goes out to Route 1. It did
Well,
prior, and then
some of it went to the lake.
yeah, right. Some of it does, but there was no net increase in impervious cover. And if they demonstrate compliance with the regulations, and that's what they were able to do.
So it was the fact that it was no net increase was the
Correct.
bottom line?
Yeah.
Yeah. So the changes were really going on around it, not on the site itself, it sounds like.
Yeah. Interesting.
Okay, and lastly, I just included some information on detailed sediment and stormwater plan review. And what that means, a detailed plan is you're doing stormwater management. So the two plans we talked about was the standard plan, minimal earth disturbance activities. Those that have to do stormwater management, we call them detailed plans. And that's where we're getting into an analysis of the cover conditions. They're looking at their pre-development stormwater management and their post-development and demonstrating compliance with state regulations on how they're going to manage and provide water quality.
Is there any follow-up? Let's take the school property, okay, as an example, because there's a huge stormwater retention pond. Is there any follow-up after all of the construction takes place to make sure that the design intent was achieved?
Yes, so the district, we do not inspect school projects. DENREC inspects all of the state and federal projects, but for any kind of residential subdivision or commercial project, our responsibility is review of the plans for compliance with state regs. We inspect that project until it's completed, meaning every home is constructed, and then we provide maintenance, inspection, and technical assistance for perpetuity. Now, I don't have the staff to go to every stormwater facility in Sussex County, but we do have a maintenance inspector, and we try to hit them every couple of years and provide reports. And then if HOAs or developers, anybody reaches out to us requesting an inspection or assistance, we have an inspector or somebody from our office will go out and meet with them.
What kinds of problems occur? For instance, in the school property, you've got this retention pond, which basically is expected to displace the water into the ground or absorb the water into the ground. Is that likely to change over the years? Does it get impacted?
It really depends what type of stormwater facility it is. Most of the time in this area, we see wet ponds. And from what we see really in this part of Sussex County, most of the ponds in the coastal areas, they're well maintained. They have pond maintenance companies that enhance them. They put the fountains in, they make them amenities to communities. So we're very fortunate here that they're so well maintained. And they really don't change that much. Things can change downstream. We really have to monitor the ponds because things could change downstream with our outlets, meaning the water's not flowing the way it's supposed to. There's a downstream obstruction or a ditch needs to be cleaned out. So there's many things that could change. The ones that we have challenges with are what we call infiltration basins or dry ponds. They're a little bit less attractive and sometimes don't infiltrate as well as we want or as designed. So those are the ones that we have a little more issues with. I'm not well informed on the school project.
Can you tell us a little bit more about pollution control strategy and pollution prevention?
So pollution prevention is associated with the construction activity. So in a detailed plan set, it'll specify what they're doing with the trash, any kind of petroleum product, concrete. So there's different details that we place on the plan to make the contractor aware that they are responsible for pollution prevention during the construction activity.
And who judges whether they're doing it properly?
Well, we have inspectors that go out. We have 4 inspectors on staff for all of Sussex County, and they're busy. And I think we're at battle with everybody, trying to make sure they keep their silt fence up and do what they're supposed to. So we're very busy.
Are there targets for reduction of waste or trash or pollution? I mean, are they, how do you judge if they're doing it well or not?
So, well, basically they have to be in compliance with the detail. And I think on here, the pollution control strategy, I think you're referring to is the inland bays pollution control strategy. Is that right? And not pollution prevention construction practices. Is that what you were more talking about?
Let's hear about it, sure.
Okay. So our stormwater regulations, which were approved this February 2019, the stormwater practices address TMDLs. And so that's with our new regulations that kind of replaced what we formerly called the PCS, the pollution control strategy. And then that was targeting different nitrogen and phosphorus removal through different projects. So basically, if they comply, if their stormwater complies with the state regulations, then they have met the TMDLs for the inland bays. So I don't know if that, did I answer your question?
So basically, they treat on site before it's released off the property?
So any kind of stormwater BMP, and there's many different practices. So it doesn't always have to be a stormwater facility. It can be bioretention or bioswales or grass channels. There's or created wetlands. There's many different treatments. But once they go through that treatment, the water should have the TMDLs and sediment removed prior to discharging to a waterway.
When a number of years ago, when we were the Planning Commission was charged with doing a study of the lakes, the city's lakes, which was pretty extensive. Of course, what we probably didn't appreciate until we did the study was that most of the pollution or most of the runoff that goes into the city's lakes does not come from the people that, in fact, have property that adjoins the lakes, but it comes from the surrounding drainage area. And in fact, the city is probably the greatest offender with the hardscape of the streets, et cetera. My question really relates to, the question came up at the time, should we be limiting or regulating in any way the kinds of chemicals that are used on the private properties? Because X percentage of the runoff comes off the property. And to what degree, in your opinion, should the city be involved, or DNREC, or whoever it is, be involved in sort of legislating the use of some of those chemicals?
I really couldn't comment on the use of, and I assume you're referring to like fertilizers and pesticides that are being used on individual properties. I think it would be very difficult to regulate. The only thing that you can do is, in my opinion, would be to educate. I think it would just be a challenge to regulate that.
Interesting. Questions? Very good.
Okay, so this is
Yeah.
very helpful.
Thanks for
Thank you.
coming.
You're
Yeah,
welcome.
we thank you. Sorry for delaying you. We never meet our time
Yeah.
schedules.
Okay. Oh, you're welcome. Thank you.
Thank you, Jessica.
Thanks very much.
Thanks.
Yeah.
Mr. Molina,
Yes.
you got anything good for us?
Well, I don't have the summary report that I usually have. We're still working with the new system. I don't want to blame the system. It's just becoming more acquainted with it. And that I would like to have that within the next the next 7 days. I'll have one shipped out to you. However, I do want to bring to the attention of the board or the commission, we have, I will say, 2 applications that have that may change the way we do calculations for buildings. And it has to be, one involves 240 Rehoboth Avenue, and also will involve 2 Rehoboth Avenue, the Papa John project. And it goes to what is considered gross floor area. And to me, gross floor area is anything which this says a building from the outside wall to the outside wall, but it also includes structures. Structures, and a building is a structure, usually roof, as according to the definition, is usually roof with walls and so forth. But then we get to the essence is, what is a wall? And the code does define what a wall is, but it says of bricks and mortars, but it also says of other similar material. So we're getting more defined into, does a railing constitute a wall? I hold that it is a wall because it defines a space. And then it goes back to the basis of when we look at FAR. FAR is for all purposes, an algebraic equation of buildings and structures divided by the gross lot area. Well, there's going to be an imbalance if I only calculate buildings and no longer calculate structures. Because now anything that is a structure that is not wall, I can't count. So we're on August 26th, the Board of Adjustment will have to make that decision, and it will shoot a lot of the, if the board upholds the applicants, it will shoot our form of calculations out the window. I don't know where it's going to go or whether we'll be able to make it.
But they're applying for variance is not a, right? I mean, they're not saying you got it wrong, they're applying for a variance.
Well, one is appealing my
Appealing,
decision,
yeah.
my interpretation.
One is- okay.
And the alternative is the variance.
Okay.
The Papa John, and I would say Papa John has been a remarkable group to work with. They are challenging that definition as well.
But who gets, I mean, Glenn, who gets to decide what the definition is?
Well, the Board of Adjustment is the clearinghouse for zoning issues. So when there's an appeal or a variance request from a decision made by the building inspector, the Board of Adjustment makes that determination. Now, I can't, it depends on how the question is framed before the board as to how wide the applicability of their decision is, whether it's just a decision that relates to that particular property or if it's something more broad that's going to relate across the city. But the application they have before them on the 26th is certainly going to be instructive on how and what is calculated as gross floor area.
Yeah, but what I'm hearing is I think I'm hearing a plea for looking hard at the code and tightening up the definitions of some of these accoutrements, embellishments, or whatever people want to call them. Is that basically what you're saying?
Well, I'm saying we need clarity. We do need clarity, and if, I mean, the code is what, 50 years old? In the 40s, something like that?
Well,
And now these are the challenges? I mean, what happened in the previous 40 years? Was this ever challenged? Why is it coming up?
Everything's being challenged today.
Yeah.
I mean, there's customs that,
Okay, thank you, Don.
all right.
Anything else?
No, that's about it.
Glenn, you got any good things for us?
I wish I had something great to discuss with you, but I really don't. I think you've hit everything that's happening right now. The one thing I came up with, Jessica, that's something that it's a discussion that's happening internally about the possibility of sending applications that have, so right now her office only sees things that are greater than 5,000 square feet of disturbance. So a lot of the properties, most of the properties in Rehoboth Beach that get redeveloped don't get sent to her office. So there is a discussion about reducing that. Kevin Williams is involved with it, but I have not reached out to Jessica yet to discuss with her how it would look and would her office. So right, it's going to increase her workload. So that's why I kind of said, listen,
No, right.
all right. So, but that'll be coming, I think, at some point.
Very good.
I have something else while Dom is still here. At our mixed-use workshop, I think we talked about the topic is going to come around again in another workshop or part of another workshop. As part of the next workshop, I would suggest that we might want to have some history about mixed use. I read lots of postings and emails about the Wilmington and what people like and don't like about it. I'd like to understand how it was built, under which set of rules. But I'm also very interested in the new construction right next door. Like, it must be like 38 or 40 or whatever it is, Wilmington, right next door to that building. I think it'd be it is mixed use. So my question is, I think it'd be very instructive if we could get permissions to sort of go through that in detail and understand whether it meets all of our code, part of our code, and we could sort of push and pull it with ideas about how, kind of like a workshop to really work with the project and see, have people react to it, see if they think it's a good thing or a bad thing. The building under construction now has a peaked roof, and of course, we had the discussions about the flat roof. It goes to the lot line on one side on the second floor, but not to the other. So I think those really concrete elements are, I don't think there's going to be, when we have the discussions, I'd like them to be specific other than I like it, I don't like it. I think we'd like to understand why, what's good about it, what might be bad about it, what we want to control,
That's a
if
very good
anything.
idea. I like that idea a lot.
Did you see Jim Ellison's letter? Yeah, okay.
Do we want a consultant here for that?
Yeah, I think we are going to try and get a consultant. I suspect that the next discussion on mixed use, we probably will wait for the survey results and get the input from Debbie.
Because it might
and-
involve other things besides just
yeah.
mixed use as well.
I mean, this is probably impractical, and I know there's, in our training, we had all kinds of discussions, but I would be open to a field trip as a group as well, just to really experience the space. Yeah, I would be willing to put the time in for that.
Yeah.
Good.
On scooters.
Anything else? A Jan motion?
No, wait, the only thing you didn't mute, the survey statistics.
Oh,
Or-
yeah, I'm sorry.
Yeah.
Yes, yes.
And we
had-
talked about, that's right, they came in after the workshop, but you sent them around to us.
Yeah,
then
and
it's
they're in,
printed
they're in
out.
your
And it's the same
folder.
stuff you sent us last
They're in the
week.
folder.
Yeah, in fact, the only thing I would say, because this is printed out, so you can't see the colors, where she has the numbers, and there's a slash and a different number, it's an update. The first number is an update of the second number.
Yeah, but it's a total. It's not the differential.
No, right, it's
It's
total.
the first
So-
number before the slash is the current total
current
whenever
total
she sent it to
from the
us,
third,
which was a
right.
week ago Saturday.
Yeah.
And after the slash is what she reported to us in July.
Right. So we're up to 530 community, that's pretty good. Right, that's excellent. I mean, considering it's going to go probably a bit higher than that, that's good. Yeah. Okay.
But we need to, you said that homeowners association is going to send out,
Well, we've done it twice already, and yeah, since this is still fairly early in August and the deadline's the end of the month, I was going to do one more, maybe around the 15th or 20th or something, yeah.
okay. Anything else?
I'd like to make the Jan motion.
A Jan motion?
Yeah.
All right, make it.
I'd like to make a motion that we adjourn.
Second?
5:20.
Okay,
So moved.
all right.
Thank you.
That's the bylaw, that the Jan motion is presumed to be a motion to.
Goes automatically to completion.
Thank you, Glenn.
Yeah, I think it definitely
Oh, and
may not be issued.
has a couple signs.
Yeah, I'm fine. I mean, I got issues out there.
I understand
It's
that.
philosophical because the planning commission is supposed to, regardless of where it is.
Jan, she's not there till after.
I think she's understand it.
I know.
Very bothersome.